Thank you for coming. Welcome to media law today. There will be a quiz, just kidding. No quiz, you're all safe. Everybody's safe. Any of my students who are looking for extra credit, make sure you sign up here or you don't get the extra credit. Anyway, a few years ago, I had approached Mr. Jones. He reminded me it was 2017 to speak to my media law class, and he was very gracious and came, did that for us. At that time, we, all the Mass Comm kids, filled one of our classrooms and had a delightful visit with him. And later, when other people heard we'd done this, they were like, "Why didn't you invite everybody?" So this time we decided we better do that and invite everybody, the campus, the community, if they wanted to come and listen to this. So he does a great presentation. We tried to get him back in 2020, and he was going to come. That was the 25th anniversary of the bombing, the Oklahoma City bombing, and COVID hit, so we had to cancel it. It made me very sad. So we're grateful to have him today. So a little bit about Stephen Jones. For more than 50 years, he said today it was 54 years, he has been involved in the defense of several high-profile cases that have involved everything from tax fraud, alleged acts of terrorism, and 2 major bombing cases, one of which was the Timothy McVeigh case. That we all know about here. Additionally, he has represented retired and former employees of the CIA and the NSA. He was also involved in consulting work with various targets, defendants, or persons of interest to the federal government for alleged acts of terrorism in the Philippines, the Far East, and those connected with attacks on September 11th, 2001. So he is known around the world for a go-to hero for these kinds of cases. Certainly. Similarly, he has represented individuals accused of disloyalty to the United States and or the unauthorized disclosure of confidential government information or classified government information. Mr. Jones has a strong working academic and professional and experience-based knowledge of cases involving allegations of terrorism, domestic subversion, espionage, electronic surveillance of all forms, including wiretapping, computer searches, roving wiretaps of cell phones, and computer surveillance. He also has experience in matters relating to the defense against extradition to the United States. He has negotiated the successful transfer of his clients who are foreign nationals to serve their prison sentences in the country of their nationality that is imposed in the United States. I've never heard of doing this, so I think that's cool because then their families can come and visit them. That's nice. He has also been involved in the defense of high-profile drug manufacturing and drug trafficking cases, as well as company conspiracy cases and allegations of money laundering. You might wonder why anybody would want to be involved in any of these kinds of cases. But I think it's safe to say that Mr. Jones is a staunch believer in the right of defendants in any case to have the best defense possible, even if they're guilty. They still deserve that. He's been active in politics. If anybody still remembers who Richard Nixon was, he knew him personally. He worked for him. He was a research assistant for him in 1964. He represented Governor Nelson Rockefeller's political interests in Oklahoma, and he worked on Governor Rockefeller's 1964 and 68 national campaigns for the presidency. He was a legislative assistant to Congressman, who was the former Secretary of Defense, Donald Rumsfeld. You recognize that name? And later a special assistant to the United States Senator Charles Percy. He also served as administrative assistant to Congressman Paul Findley of Illinois and has represented 3 of the Republican governors of Oklahoma. Mr. Jones was the Republican Party nominee for the Attorney General in Oklahoma in 1974 and for the United States Senate in 1990. And we were just at lunch talking, and he was the defense attorney on the Richard Melton? Is that his name?
Keith Melton.
Keith Melton case that just happened here in Woods County during this last year. So anyway, Mr. Jones.
First of all, it is a genuine pleasure to be here today, and thank you for giving me some of your time. I hope it will be informative and interesting. I'm going to start with, and I hope, with a 10-minute excerpt from a BBC documentary on the Oklahoma City bombing, which I think is the best documentary that I'm aware. You will hear the bomb explosion toward the very beginning of the program. I've used this for 25 years, and it plays through to the end, which is about 10 minutes. And then I'll talk to you about some of the things I learned and observed and might be of interest to you today.
It says it's there. It doesn't want to be moved. Okay. I just need to write it inside.
There are 4 elements that I have to receive information regarding my
It did break down because it was the boy next door and trial for murder.
I had a job. Knowing that I was defending a man who told me he was guilty. Tim saw himself as a rescuer. He believed that he was preventing a greater harm. Not a martyr, a patron. The type of man who would believe that 50 years from now, his statue would be on the mall in Washington.
We're not sure exactly how many. We've got the word that there might be a daycare center down in Boulder.
Two-and-a-half-year-old little girl, fair skin, red hair, and blue eyes. She is in stable condition right now, but they need to take her to surgery. We don't know who she is. We don't know who her parents are.
I guess my nephew like is dead. Then you put your dead on a piece of concrete.
I just can't comprehend the pretend that I know to be responsible for such a monstrous act. There was no building, just rubble. And the building was gone. I didn't see any people up in the windows. There weren't any windows. The cars were still burning, and there was a lot of smoke. People were running and screaming. People were bleeding. I've never seen anything like that, and I hope I never see anything like that again.
The next morning, at 6:30, the chief medical examiner announced that 32 bodies had been recovered, 12 of them children under the age of 6. More than 24 children lost both parents. More than 200 lost one. Grandmothers and grandchildren, aunts and uncles,
seeing Tim in the courtroom, seeing Tim on TV, reading about the demands that Tim makes, I think he thinks he's a celebrity. When McVeigh's sentence is announced, crowds gather around the television crew, getting word from a two-way radio, relaying the information directly to Tom Brokaw.
The jury recommends, by unanimous vote, that the following sentence be imposed. The defendant, Timothy McVeigh, will be sentenced to death.
And so 3 months after it begins, one of the biggest trials in U.S. history goes down as a model for the legal system, described by observers as justice at its best.
This is the CBS Evening News. With Dan Mather reporting tonight from Denver.
Good evening. The jury that convicted Tim McVeigh, the deadliest act of terror on U.S. soil, has decided his punishment. Acting as what the judge called the conscience of the nation, the jury recommended that McVeigh be put to death for bombing the federal building in Oklahoma City, killing 168 of his fellow Americans. It was the decision many in Oklahoma were waiting for and, frankly, hoping for. The Oklahoma governor called it, and I quote, right and proper. Our coverage begins here in Denver with CBS News correspondent Scott Pelley at the U.S. Courthouse. Scott.
Tim McVeigh was escorted out of the courtroom by 4 federal marshals. As he rose after the verdict, he turned and looked at his parents and mouthed the words, "It's all right." The sense here at the courthouse among the lawyers, the victims of the bomb, and the families is one of exhaustion. Just moments ago, the lawyers spoke about the verdict.
This is not a day of great joy for the prosecution team. We're pleased that the system works and that justice prevails. But the verdict doesn't diminish the great sadness that occurred in Oklahoma City 2 years ago. Our only hope is that the verdict will go some way to preventing such a terrible, drastic crime from ever occurring again. Thank you.
The jury has spoken, and their verdict is entitled to respect, and all Americans should accord it that respect until such time, if ever, it is overturned by a court of competent jurisdiction. We ask that the barriers and intolerance which have divided us may crumble, that suspicions disappear, and that hatreds cease, and that our divisions and intolerance being healed, we may live together in justice and peace. God save the United States of America. God save this honorable court.
I'm going to reserve time towards the end of my remarks for questions that you may have. But let me begin by telling you a little bit about the Oklahoma City bombing case and how I became associated with it. When the bombing happened, which was on April the 19th, 1975, it was the second anniversary of the Mount Carmel or Waco Branch Davidian raid or attack or assault, whatever you wish to call it, by the FBI on their compound or residence at Waco, which is incidentally the series now being shown on Showtime, and then in the month of April there will be Waco 2, and then after that I think there will be a 6-part episode based on my book, Others Unknown. The significance of Waco and the assault there grows in American history and is one of the primary causes of the bombing in Oklahoma City. And I'm able to speak with you tonight, or this afternoon, with some freedom, because ordinarily what happens between a lawyer and his client, particularly on matters of verbal or written communication, are privileged. That is to say, they cannot be disclosed by the lawyer. The client can disclose them, but the lawyer can't. but Tim McVeigh made a series of very ill-advised personal decisions without informing his subsequent lawyers who handled the appeal, and he gave 75 hours of on-the-record interviews with 2 Buffalo newspaper reporters who wrote a book. And after Tim had spoken for 75 hours, there was really hardly anything left of the attorney-client privilege. And there are sealed orders in various courts and bar associations affirming that his actions waive the attorney-client privilege, thus allowing me to speak with you with some candor today. When Mr. McVeigh was arrested at Perry by a highway patrolman, when the federal authorities decided he was a suspect and where he was, they airlifted him after the walkout at Perry to Tinker Air Force Base by helicopter, where he was arraigned before United States Magistrate Judge Howland. And at that time, he was represented briefly by the federal public defender and by a lawyer that she had brought with her. However, almost immediately, they moved to withdraw from the case for various reasons, and so the court had to find a new lawyer for Tim McVeigh. My wife, Cheryl, who herself at that time, or shortly thereafter, was a columnist for 17 years for the Oklahoman, told me that she was certain that they would call me to represent Tim McVeigh. I did not think that was true. I told her that that wasn't the way the system worked, but as you heard from the introduction, there are some aspects of my professional background that would make one think that I might be called. I myself did not think that, and certainly undertook no initiative to bring any interest I might have in representing him. As I told the Enid newspaper when I was appointed, I was a draftee, not a volunteer. But the Crimes and Offenses Act of 1790, which was the 13th piece of legislation adopted by the second session of the first Congress, meeting in New York City, provided that anyone charged with murder in federal courts was entitled to a lawyer to, quote, make his full defense. And from that early beginning in our law, through various passages and amendments to the Act, persons charged with felonies, not just murder, but felonies, were entitled to have a court-appointed lawyer. In the federal system, there is a system of public defenders who are appointed and under the supervision of the administrative office of the courts, and they represent indigents, people that cannot afford a lawyer in federal court in criminal cases. Then, because there are sometimes conflicts of interest, there are certain lawyers that are on a panel outside that group that are called in occasionally to represent individuals. I was not a public defender, and I was not a member of what's called the CJA panel, which is the criminal justice panel. However, I had somewhat extensive experience in the criminal law, and in particular offenses related to acts of terrorism, whether political or unrelated. So my work was not unknown. About 2 weeks after the bombing, I was in Oklahoma City and returned to my office. It was after 5 o'clock, and there was a note pinned to my chair that Chief Judge Russell, federal judge, chief judge, for what's called the Western Judicial District of Oklahoma, which is the western half of the state, wished me to call him. So I attempted to call him and went to record him. So I left my number and name and told him I was returning his call. And that night, about 9 o'clock, I was home alone. My wife was out. My children were in school at college. The phone rang, and I answered it. And their voice on the phone, as though coming from a great distance, said, Mr. Stephen Jones. And I said, yes. And the voice said, Mr. Jones, This is the Department of Justice Watch Command Center in Washington, D.C. Please remain on the line for Chief Judge Russell from Oklahoma City. So I was surprised, but I grabbed the legal pad, which I had by the phone, pencil, thinking it might be something that I needed to take notes on. And in a few seconds, I heard Judge Russell's voice, and the voice in Washington said, "Your Honor, this is a secure line. Mr. Jones is on the phone." And Judge Russell said, "Well, Stephen, I guess you know why I'm calling you." And I said, "Your Honor, I have no idea why you're calling me." And he said, "Well, then I'll come straight to the point. We've had a meeting down in Oklahoma City, and the other judges and myself, and we have a question we want to ask you." And I said, "Yes." And he said, "The question is, if asked, would you agree to represent an individual who has been arrested or will be arrested in the Oklahoma City bombing?" And I paused for a moment and I said, "Well, I don't have a professional problem with it. I understand what you're trying to do, and certainly I've been involved in controversial cases, but I've never been involved in one in which I thought that my wife or home or children or business associates or even the building where I practice law could be at risk. So I think in fairness to them, I should probably ask their opinion." And he said, "How long will that take?" And I said, 24 hours. He said, "Call me back at this number tomorrow at 6 p.m., which was less than 24 hours, 21 hours, and tell me your answer." So we talked for a little while longer, and although he never said he would appoint me to represent Tim McVeigh, that was clearly where the conversation was moving. So I hung up the phone and thought. I remember it was a stormy night, it was raining, wind was blowing, lightning, all of that you might expect in May. And then my wife came home probably about 10:15, came in the back door, and I called her. I said, "Booter," one of my nicknames for her, "can you come in the library? I have something I want to tell you." And she came in the library, and she said, why are all the lights off?" And I'd forgotten to turn the lights on. I said, "Well, Raider," another nickname for her, "the call that you were afraid would come has come." And my wife sat down and she said, "Oh my God, what are you going to do?" And I said, "Well, we're going to talk about it, you and I, and try to come to some decision, and we'll call the children, see what they say, and talk about it, think about it." So we did. We called the children about 2:30 in the morning. And my son, youngest son, was in military school. I arranged immediately for security for him by service authorized to carry firearms. Told my daughter she was at Westminster College. School was out to come home the next day. And my other two sons, one was in Texas and one in San Francisco. They were older. So the next day I met with probably 15 people in and around Enid whose views I very much respected. They were clients and wanted to get their input. And then the last call went to Governor Keating, because at that time I was special counsel to the governor, and he and Kathy were not only friends, political allies, but clients. So I reached him and I told him, I said, "Governor, friend David Russell has called me and asked me to represent what I believe will be Tim McVeigh in the Oklahoma City bombing case." And the governor said, "Well, I don't think you should do it. It's not going to help your career. And besides that, you're our lawyer and you're working to help me on administration." And so I wouldn't do it. And so I got a little pompous. And I said, "Well, Governor, you're a lawyer, you're a former FBI agent, United States Attorney, Deputy Attorney General, nominated for the 10th Circuit by the President of the United States. You know he's certainly entitled to a lawyer." And Governor Keating said, "Oh, hell yes, I know that. He's just not entitled to my lawyer." And so I thanked him for his views and called Judge Russell and repeated the question back to him. And he said, "Great. I said yes. The answer to your question, I repeated, and I said the answer is yes. And he said, great, I appoint you to represent Tim McVeigh. Be in my chambers at 1:30 Monday, ready to go to work. I've always been grateful to the judge for giving me a weekend to think about it, because I certainly did. And I decided the first thing that I had to do was to get more help and find other lawyers for all of my clients, because I knew that I would not have time to be involved in anything else. So Monday afternoon, I went down to his chambers and swore me in as Mr. McVeigh's lawyer. Then asked everyone to leave his chambers, and he shut the door except for me. Came over and I stood up. The judge was in his shirt sleeves. He'd taken off his robe. He said, well, Stephen, I hope I haven't signed your death warrant. I said, well, David, first time I've used his Christian names. And said, no, Judge, I can assure you that makes two of us. And I said, well, good luck to you. The marshal is outside. He'll take you to meet your new client. So we drove over to El Reno, and I met Tim McVeigh, and for the next 2.5 years I was his lawyer. I'll give you a general overview of the case. Two things needed to be done as Mr. McVeigh's lawyer, two overall overreaching things. One, he was already being called the most hated man in America. I do not know whether that's true. It's certainly true in Oklahoma. So the first thing I had to do was to arrange security for my office, my family, and my home. And to the extent that I benefited from that, then I also was protected. I slept with a revolver under my pillow. I had a loaded shotgun in my house. It was patrolled day and night by security officers. One member, one lawyer on the defense team was authorized to carry a concealed weapon. And wherever I went or rented an apartment in Denver, security was provided. And as I said, there was security not only in my home, but in my office. Second, I had to get help. Obviously, such a case was far more than one lawyer could devote to it, and I ultimately ended up hiring 17 lawyers to work on the case, probably 10 to 12 staff members, and maybe 7 investigators. The defense of Mr. McVeigh and Mr. Nichols cost $20 million. I'm sure most of that was Mr. McVeigh. The Nichols team approached the matter an entirely different way. I would estimate that the cost of Mr. McVeigh's defense to be approximately $17 million. I was his lawyer for 2.5 years. I recognized that there were certain things we had to do to guarantee him a fair trial, what I would call legal considerations. We had to get a change of venue out of Oklahoma, which we got to Denver. We had to recuse all the Oklahoma judges, which we were able to do. Judge Mage was assigned. We had to get adequate funds to represent our client, which we got. We had to get a severance from Terry Nichols, so we had a separate trial. We achieved that. We had to have the time to build the defense. We achieved that. We had to suppress some of the evidence, and we achieved that. So all of our legal objectives we achieved. And each one of them, each time we were successful, the media shocked, amazed. That would never happen, and it happened. In all of American history, there's only 17, at that time, federal cases that had been moved on a change of venue. We were the 18th. To get Judge Mage, who was an outstanding judge and certainly protected me and the professional staff I had, they thought the Oklahoma City judges. Originally it was going to be Judge Alley and the trial would be in law. That didn't happen. People wanted the trial within a year. We were able to get it for 2 years to almost 2.5 years. So in that respect, we were successful. Then we had to think of a defense for Timothy McVeigh, and we had to develop that defense. I was of the opinion without unnecessary elaboration, that first of all, we could not put Tim McVeigh on the stand. And number two, while Tim McVeigh had told me he was guilty, I did not believe what he told me. So I had to investigate. And in the course of that investigation and the preparation for the defense, I went to the United Kingdom, to London, Northern Ireland, Scotland, Syria, occupied territories, Palestinian Authority territories, Israel, Jordan, Hong Kong, Manila, People's Republic of China, South Korea. I think that's all of the foreign countries. Many places in the United States, from rural co-ops and grain elevators in Kansas to trailer villages on the California-Arizona border. I visited with some of the most fanatical people on the face of the earth, but also had tea with Barbara Walters in her apartment, and dinner with her at the Cirque in New York, breakfast with Peter Jennings, and dinner at Club 21 and Sound of the Dove with Dan Rather. I met the Attorney General of the United States, and lots of interesting people. The case was so large, there were about 35,000 interviews conducted by the FBI. We read every one of them. There were over 100,000 photographs, probably 500 hours of video and audio recordings, and of course 168 deceased people, each one of whom was photographed 7 times at the site where their body was recovered, and I was given that file, all files. We also investigated in Israel bomb trace analysis, Hong Kong, various activities of people of interest to us, and we found expert witnesses. Our pathologist was the retired chief state pathologist for Northern Ireland, Sir T.K. Marshall, who had performed autopsies on over 3,000 people killed by the use of ammonium nitrate bombs, and conducted the autopsies of the 353 people who died in the area in the bombing over the Atlantic Ocean. It was a major undertaking. In terms of his defense, my view was that the government's case to prosecute him was built on a table, and the table had 6 legs, and I identified the 6 legs. One was where Tim McVeigh was arrested. Number 2 was what was with him when he was arrested. Number 3 were the 40 heirs who were government witnesses. Number 4 was the Darrell Bridges debit card. Number 5 was the FBI laboratory. And number 6 were the so-called eyewitnesses. My theory was that if we could knock out 3 of those 6, the table would collapse and the jury would either return a not guilty verdict or a verdict of a lesser offense or be a hung jury. That was upset by a defense investigator, an individual that I had known for 20 years and certainly trusted, who, for reasons that I never fully understood, gave the Dallas Morning News access to our mainframe computer and roughly downloaded 1 million pages of documents related to the defense. Our defense was the government has charged Tim McVeigh, so now prove it. Is your evidence sufficient to convict a jury of 12 people instructed under the law, procedure, and evidence of what the crime is, to find him guilty beyond a reasonable doubt? Or is there a weakness to your case? I wanted to present what I consider to be an honest defense. Now, the 800-pound gorilla in the room was the media. So let me speak just a little bit about that. A substantial part of my time, other than supervising and leading the defense, was in media relations. At that time, the internet had not taken the full share of the media market that it has today. So I was dealing with both the traditional electronic media, television and radio, as well as print media. At the trial, there were about 2,500 accredited journalists. And by the time of the trial, McVeigh's conviction was not automatic. I mean, people believed, at least the media believed, that the case was sufficiently close enough that they needed to be in Denver to cover it. So the Nichols people took the position they didn't want to talk to the press at all because they just wanted people to forget that Terry Nichols was a defendant. In my case, my client, we did not have any proof that spoke for him. His sister had been given immunity and was cooperating with the government, reluctantly, but cooperating. His mother would not talk to us. His other sister would not talk to us. And his father simply was incapable of communicating what he felt. There was no association of defendants, and there was no media other than perhaps one or two that took our position. So talking and explaining the legal aspects to the media was time-consuming. It was necessary because unless we did that, then the public from which the jury pool would be chosen would only have coverage from the government. So the first thing that we did was get our own photographer to take pictures of Mr. McVeigh and videos, some of which you saw, to offset what I call the 1,000-yard stare when he came out of the Noble County courthouse. The other thing we did was release his military record. Tim had won the Bronze Star for service, the Army Commendation Medal with 2 upgrades to Valor. He's very popular with the troops that he worked with. His record in high school was commendable. He had won a small scholarship to the state university. And so we thought that there were elements to work with. And all of that, some media were hostile to us. ABC, I felt it was a waste of time for me to talk with them, although Diane Sawyer and Barbara Walters were exceedingly gracious. Miss Sawyer and I had a common link. She had worked for Mr. Nixon, and I had worked for him directly and personally when he was a lawyer on Wall Street, although my work was political. Mrs. Walters was probably the most talented female interviewer, and certainly one of the major interviewers, period, in the world. NBC was, I thought, not as fair as they could have been. CBS, on the other hand, and Dan Rather were very balanced, and they always gave fair coverage to us, and frankly to me personally. In the media, of course, the Oklahoman was a lost cause, Oklahoma City newspaper. The Economist, which in my opinion is the world's best English-speaking magazine, news magazine, was very fair and objective as per its reputation of 159 years. The New York Times was balanced. The Los Angeles Times was balanced. The Washington Post did not give us really the major consideration because it's the national newspaper in Washington where, of course, all politics is germane. The Denver papers were interesting. Just before the trial started, John Benet Ramsey had been murdered, the 6-year-old, and Denver was a clearly competitive newspaper town. The Rocky Mountain News was a kind of tabloid, but had actually the largest circulation, and then there was the Denver Post. Between them, they reached an agreement that the Denver Post would cover primarily the John Benet Ramsey case, and the Rocky Mountain News would cover the bombing. That was, in a way, a loss to us because the Denver Post was very skeptical of the government's theory, and that helped us build reasonable doubt. Just before John Benet Ramsey's tragic death, the Denver Post had ran a 6-page supplement devoted to one issue, and that is a balanced objectivity of the claim that the bomb had been constructed at Gary State Lake. And I was looking forward to other series that would undermine the government's theory, at least in the public at large. But the Denver Post dropped out. I certainly have no complaint against the Rocky Mountain News because they were very fair. I wouldn't say they were investigated as the Dallas Post was. With respect to the media, electronic media, you saw all the reporters around me. That was the daily scene when I walked to the courthouse in Denver. Every morning, I was surrounded. When I came back for lunch, I was surrounded. When I went back after lunch, I was surrounded. And when I returned in the evening, I was surrounded. That was my perk wall, if I can use that expression. Judge Mage ultimately entered what's known as a gag order, restricting the attorneys from making comments as both the government as well as myself. It was somewhat effective against us. We were pretty circumspect. And I don't see that it really stopped the government at all. I thought their media actions were calibrated to help in their case. There was one rather dramatic closed-door conference involving myself and government attorneys in which Judge Mage came down on my side. And Judge Mage was a brittle man, but he was very fair and objective, and he was certainly fair with me, both personally and privately and professionally. And also to Mr. McVeigh. It's an interesting dynamic. They seem to respect each other. Kind of like they had their roles. McVeigh recognized the judge as the judge. He recognized the defendant, always referred to him as Mr. McVeigh, and did not in any way attempt to be judgmental. His interest was in being fair. Also, he took a special interest in me. I remember one time when we were talking, he said, "Now, Mr. Jones, it's very important to the court that you be ready for trial physically and emotionally, so I don't want you flying tourist. I want you to fly business class. I want you to fly business class and first class overseas. I want you rested. I want you protected. And if there's anything I can do to help in that direction, I want to do that." And he said, "Is it necessary? I accept the integrity of your representations, and whatever you need, just tell," gave me the person's name, "and I would accept what you need, and I would prove it." He never turned down anything that I needed. It was a refreshing and rewarding experience. So, you're at class ends, yes?
It will soon, but we want to see if we've got some
Yes,
questions.
I was just about to.
Your burning questions you always want to have answered.
All right, so I know that class will end shortly, and I'll stay in case anybody asks questions afterward. But if you have any questions now, I will address them. I will try to address them.
So, did you expect that the jury would sentence him to death, or what was your worst outcome that you thought about it?
The charge against McVeigh, incidentally, was unprecedented. First time the charge was use of a weapon of mass destruction. My view toward the end, the government's strategy was different than what I thought it would be, and I thought that he would be convicted. Now, the death penalty, since it only takes one to oppose the death penalty for it to go to life, we put on, I thought, a strong mitigation case. But my own feeling was that once the jury convicted him, and punishment comes second, that if they convicted him of the charges, that the result would be the death penalty. Yes?
Were you able to poll the jury after the verdict?
No, and I'm not, I think the judge told them. And I think he asked them, "Is that your verdict?" And they said, "Yes." They took 4 days. I can't complain about it.
So they didn't give you any information, and sometimes
No.
the jurors are...
That's frowned upon in federal court. Although NBC later, the night I appeared on 60 Minutes, NBC encountered that. They brought the jurors all to Oklahoma City and interviewed them, and they talked more, but I didn't watch it because I was being on television at the same time. Yes, sir.
Did you ask for the change of venue, and why did you pick Denver for the federal court?
I asked for a change of venue, as did Terry Nichols. I didn't specifically mention Denver, but I thought that's probably where it would go. Once I knew that it would be Judge Mage, and Judge Mage was chief of the United States District Court, and Denver was really the only city in the 10th Circuit large enough to accommodate this trial. And he was the top dog. He was chief judge of the federal court, so whatever he wanted to do would be done. So I thought we were going to Denver. Yes, ma'am.
So since you were a draftee and you described being like worried about being you described your wife being worried about what would happen. What was the thing that really pushed you to decide to say yes?
Well, fundamentally, my oath as a lawyer. Lawyers are required under their oath to accept assignments from the court unless there's a conflict of interest. I had no conflict. I felt I was qualified. I practiced law 25, 30 years. I had worked in government. I worked for a man that became president of the United States. I certainly had criminal defense experience and death penalty experience. And I did not think it was appropriate for me to decline the appointment. I knew it would be difficult, but no one forced me to go to law school. It is not true. I was walking across the University of Oklahoma campus, somebody put a pistol to my head and said, go register for law school. And once you sign in for a penny and for a pound.
Thank you.
Well, thank you all for coming out, and I appreciate your attention and your interest.